She called him a trespasser in front of 400 guests. The chandeliers above the grand reception hall caught the last light of the evening and threw it down across the surface of Crystal Pines Lake, turning the water into something that looked like shattered gold. Victoria Harrington stood at the center of it all, dressed in white, holding a glass of champagne like a scepter, and when she spotted Ethan Brooks moving quietly through the edge of the crowd, her expression shifted from practiced elegance into something harder and colder. She raised one hand. She pointed at him. Two men in dark jackets were already moving before the word left her mouth. Ethan did not run. He did not raise his voice. He simply walked to the reception table, set down a worn manila envelope, and waited. Inside that envelope was a single document, a deed of ownership registered and unbroken, bearing his family's name, dated to a year when Victoria Harrington was likely still in grade school. The resort behind him, $12 million of polished timber and imported stone and custom lighting, stood on land that had never, not once in 48 years, belonged to anyone but the Brooks family. And Ethan had let them build every last inch of it. Ethan Brooks was not a complicated man, and he had never wanted to be. His father, Thomas Brooks, had purchased 45 acres of lakefront property in 1978 for reasons that had nothing to do with investment potential or long-term capital appreciation. Thomas had simply wanted a place where the noise of the world stopped, where the only sound in the early morning was the wind moving through the pine trees and the occasional knock of a heron landing at the water's edge. He paid $31,000 for the land, drove out on a Saturday morning with a thermos of coffee and a folding chair, sat on the bank of Crystal Pines Lake for 3 hours without saying a word to anyone, and decided it was worth every cent. Ethan grew up on that land the way most children grow up in houses. It was simply the backdrop to everything real that happened in his life. He learned to fish at that lake when he was 6 years old. Standing beside his father in knee-high rubber boots that were 2 sizes too large, holding a bamboo rod with both hands and trying to be still. He was not very good at being still. But his father was patient, and the lake was quiet, and eventually the stillness came to him the way it always does, slowly and without announcement. He came back to the land when he was in his 30s and brought a woman named Sarah with him. They were married by then, and Sarah had never been a person who made a great fuss over scenery, but she stood at the edge of the lake on the afternoon he first brought her there, and said without any drama that she understood why he loved it. That was enough. They spent weekends there when they could, and after their children were grown and gone, they spent more time there than anywhere else. Sarah died in the early part of a winter, 8 years before the events of this story, quietly and without much warning, the way some deaths happen not with crisis, but with a slow fading. Before she passed, she asked Ethan to spread some of her ashes at the lake. He did, near the eastern bank beside the old wooden dock where they had sat through more evenings than he could count. He did not mark the spot with anything visible. He did not need to. He knew exactly where it was. After Sarah was gone, Ethan made a habit of walking down to the lake every morning before 7. He did not always fish. Sometimes he simply stood there and watched the light come across the water, and it was enough. The land had always been more than property to him. It was the one place on earth where he felt his life had a shape he could recognize, where the past and the present sat side by side without conflict. He paid his property taxes every year without missing a payment. He maintained the access road at his own expense. He kept the deed in a fireproof box in his study alongside his marriage certificate and his discharge papers from his time in the service. The thought that any of this would ever be in question had genuinely never occurred to him. Then one Tuesday morning in the middle of October, he drove out to the lake and found a sign standing at the entrance to his property that had not been there 3 days before. The sign was large and professionally made, mounted on 2 posts of treated lumber with a rendering of a building he did not recognize printed across it in bold colors. The text at the top read, "Future home of Crystal Pines Luxury Resort, a Green Valley Estates Community Development." Below the image of the building was a smaller line of text with a projected completion date and the logo of an organization he recognized only vaguely from the neighborhood association paperwork that occasionally arrived in his mailbox. Ethan stood in front of the sign for a while. He did not feel angry immediately. He felt more precisely confused, the way you feel when something in front of you does not match any category your mind has prepared for. He thought reasonably that the sign had been placed in the wrong location. Property lines were misread all the time. Surveyors made errors. He walked back to his truck, found the phone number for the general contractor listed on the bottom of the sign, and called it. The number forwarded him to a woman who identified herself as the project coordinator for Green Valley Estates HOA and told him politely that someone would be in touch. The someone who came was Victoria Harrington. She arrived 2 days later in a black SUV with tinted windows, dressed in a blazer despite the weather, and she walked toward Ethan with the particular confidence of someone who has spent years treating every conversation as a negotiation she has already won. She was perhaps 60, with silver hair pulled back precisely, and she moved through the weeds at the edge of his property without looking down at her feet, which Ethan noticed. She introduced herself, shook his hand once, and without pausing long enough to let him speak, explained that the Green Valley Estates HOA had a recreational easement that covered this portion of the lakefront, that the development had been fully approved by the county planning board, and that construction would begin within the month. She said all of this pleasantly and at a pace that discouraged interruption. Ethan waited until she finished. He asked her to show him the easement documentation. She said her office would provide whatever was needed. He asked if she had reviewed the deed for this property. She smiled in a way that was not quite a smile and said that the HOA's legal team had handled all of the relevant title research. He said that was interesting because to his knowledge, the land had never been transferred to any party, and the easement on the property, which he had reviewed himself years ago, covered drainage and maintenance access only, not commercial development. Victoria looked at him for a moment with an expression that suggested she was recalibrating something. Then she thanked him for his time and said she was certain any confusion would be resolved quickly. She walked back to her SUV without changing her pace. Ethan watched her go. He did not feel angry yet, but he felt with a certainty that settled in his chest like cold water that something was deeply wrong. The county recorder's office was a low brick building 3 blocks from the courthouse, and it smelled the way all county offices smell, like old paper and fluorescent light and the particular staleness of rooms that have been heated and cooled through too many decades. Ethan arrived at 9 in the morning and asked to see the complete file on the parcel he had owned since inheriting it from his father. The clerk who helped him was a woman named Margaret, who had worked in that office for over 25 years, and who had the rare quality of a person who takes genuine pride in the accuracy of public records. She pulled the file herself rather than delegating it, spread it across a long table in the back room, and walked Ethan through it page by page. What the file showed was unambiguous. The land had been purchased by Thomas Brooks in 1978. It had passed to Ethan Brooks upon Thomas's death with no interruption in title. Property taxes had been paid without a single gap for 46 consecutive years. There had been no sale, no transfer, no judgment lien, no encumbrance of any kind placed against the property since the original purchase. The easement recorded in 1983 explicitly described its purpose as drainage maintenance and limited access for utility upkeep. The words commercial development, resort, hospitality, or recreational facility appeared nowhere in the document. Margaret said in the careful language of someone who chooses her words on the basis of what she can prove, that the record she had on file showed clear, uncontested ownership in his name, and that nothing in those records would support the kind of claim the HOA appeared to be making. Ethan thanked her and drove home. That evening his phone rang with a number he did not recognize. The man on the other end identified himself as a senior attorney representing Green Valley Estates HOA and said without warmth that Ethan would be well advised not to pursue any further inquiry into the project, that the HOA's position was legally sound, and that any interference with the development timeline would result in legal action against him personally. The attorney did not raise his voice. He did not make explicit threats. He spoke in the smooth, even tone of someone who is accustomed to people backing down. Ethan thanked him politely and ended the call. He sat in his kitchen for a while after that. He thought about the fact that the attorney had not denied the deed. He had not said the land did not belong to Ethan. He had said only that Ethan should not interfere, which meant they knew exactly whose land it was. The machines arrived before dawn on a Monday, and by the time the sun was fully up over the tree line, the sound of diesel engines and hydraulic arms had replaced the quiet that Ethan had associated with that stretch of land for nearly his entire life. He drove out and parked on the road at the property boundary and watched. The first trees to come down were the old white pines along the southern ridge, the ones his father had always said were at least 80 years old when he bought the place. They went in minutes. The dock where he and Sarah had spent so many evenings was pulled out and broken apart by the end of the first day. The footpath along the eastern bank, which Ethan had worn into the ground over decades of morning walks, was graded flat and covered with fill. He stood at the boundary with his hands in his pockets and watched a machine roll over the ground near the eastern bank, the ground where Sarah's ashes lay scattered in the soil. And he felt something move through him that was older and quieter than anger. It was not grief exactly, or not only grief. It was more like witnessing a particular kind of desecration that the law in its current form had not yet caught up with. Victoria did not acknowledge him when she drove past in her SUV. She looked through him the way you look through a window rather than at it. The construction crew, to their credit, seemed vaguely uncomfortable when they recognized him watching from the road. Two of the younger workers looked away, but they kept working. The HOA had scheduled an aggressive timeline, and the project manager posted updates in the local paper with the regularity of a political campaign. Victoria gave a brief statement to the local news in which she described the resort as a transformative opportunity for the region's economy, a development that would bring jobs and tax revenue, and put Crystal Pines on the map for a new generation of visitors. The reporter did not ask about the property title. The planning board had approved the project. The mayor had issued a statement of support. The narrative in town was already written. This was progress. This was good. And anyone who opposed it was standing in the way of something beneficial for everyone. What Ethan found as the weeks passed was that people in town had absorbed that narrative completely. At the feed store, at the diner, at the gas station where he had filled up his truck for 30 years. People he had known his entire adult life would look at him with an expression that mixed sympathy and mild impatience, as though he were an elderly relative who needed to be gently talked out of a bad idea. A few people told him directly that he ought to let it go, that the resort would be good for property values, that he was too old to fight something like this and should take whatever the HOA offered and move on. Nobody asked to see his deed. Nobody asked what the easement actually said. The story had already been decided, and in that story, Ethan was a stubborn old man who was preventing something good from happening. He did not argue with any of them. He went home and opened the file he had started keeping on his desk, and he read through it again, and then he kept reading. It was late on a Thursday night when he first noticed the discrepancy, and he almost missed it. He had requested a copy of the survey that the HOA's contractor had submitted to the county planning board as part of the development application public records available to anyone who asked, and he had laid it on his kitchen table beside the original survey conducted when his father purchased the land in 1978. The two documents described the same parcel in language that should have been identical. They were not. The eastern boundary line on the HOA's survey had been moved. Not dramatically, not the kind of shift that would catch the eye of someone reading quickly but precisely and deliberately approximately 400 feet inward from where the original survey had placed it. 400 feet, which happened to be almost exactly the distance between the actual property line and the western edge of the resort's planned footprint. He checked it 3 times. He checked it a 4th time by driving out with a tape measure and walking the line himself on a cold morning, while the construction crew was on a break. The original survey markers, the iron pins that had been set in the ground in 1978, were no longer where they should have been, according to the HOA's version. They were not visible at all. Ethan looked at the construction company listed on the new survey and spent 2 evenings tracing its ownership structure through the county business registry. The company had been incorporated 4 years earlier. 2 of its 3 listed principals shared a mailing address with a limited liability company that appeared in the HOA's corporate filings as a contracted services vendor. He drove to the home of a retired land surveyor named Leonard Casey, who had worked in the county for 31 years before his retirement, and who in retirement had developed the specific brand of bitterness that tends to come from watching one's professional standards erode. Ethan spread both surveys on Leonard's kitchen table and asked him what he saw. Leonard looked at them for a long time without speaking. He pulled out a ruler. He made some calculations on a notepad. Then he looked up and said that the newer survey contained a boundary shift that was not supported by any legal instrument he could find in the county records, that the methodology used to justify the new line was technically defensible, but practically designed to obscure the alteration, and that, in his professional opinion, someone had deliberately redrawn a property boundary to incorporate land they did not own into a development footprint. He said it the way you say something you have suspected for a while and are not particularly surprised to have confirmed. He asked Ethan what he intended to do about it. Ethan said he was working on that. The 2 of them agreed to go out the following morning with a metal detector and find the original survey markers. They went at first light before the construction crew arrived. The lake was flat and gray in the early morning, and the machines sat quiet at the edges of the site like large animals at rest. Leonard had brought a professional-grade metal detector and a GPS unit, and he moved methodically along the line of where the original boundary should have been based on the 1978 survey. Ethan followed behind him with a notebook and a camera. 40 minutes in, on the eastern side of the property, the detector gave a sustained signal, and when they dug down 4 inches through the packed earth and construction debris, they found the iron pin original survey marker still in place, bearing the county registration stamp from 1978 positioned exactly where the old survey said it would be, and exactly 412 feet from where the new survey claimed the property line ran. Leonard photographed it from multiple angles, recorded the GPS coordinates, and cross-referenced it against his own calculations. He said in the flat declarative voice of a man giving expert testimony that based on this marker's position, the entire footprint of the resort construction currently underway was located on land belonging to Ethan Brooks. Rachel Morgan had a reputation in the county for being thorough in a way that bordered on obsessive, and for being the kind of attorney who enjoyed cases that other lawyers declined as too complicated. She met Ethan in her office the following week, reviewed the materials he brought her, without expression, asked 2 sharp questions about the timeline of the construction and the HOA's corporate structure, and then sat back in her chair and said she needed a few days to pull additional records. When she called him back, her voice had an edge of genuine interest that had not been there at the first meeting. She had found something else. The notarization on the document the HOA had filed to establish their claimed easement rights, the document that formed the basis of their entire legal position, bore the certification stamp of a notary public whose license had been surrendered to the state licensing board approximately 14 months before the document's filing date. The signature was valid. The stamp was genuine, but the notary had not been legally authorized to perform the certification at the time it was executed. Rachel said that in her view this was no longer a property line dispute. This was fraud. She also said she had a strategy and that it was going to require patience. Ethan had patience. He had been practicing patience at that lake for most of his adult life. The strategy Rachel proposed was straightforward in outline and required considerable discipline in execution. She would not file for an injunction to halt construction. She would not send a cease and desist to the HOA's attorneys. She would not make any public statement or file any court motion that would alert Victoria Harrington to the full scope of what they had assembled. Instead, they would wait. They would wait while the HOA finished the resort. They would wait while it opened for business and began receiving paying guests. They would wait while investors committed additional capital and the property became fully operational. Then at the moment of maximum exposure, when the financial stakes were at their highest and the public profile of the project was at its peak, they would present the complete case in court. Rachel explained, in the calm manner of someone who has calculated risk carefully, that this approach would maximize both the legal remedy available to Ethan and the personal and financial consequences for the individuals responsible for the fraud. It would also, she said, make it impossible for the HOA to quietly dismantle the project and walk away with limited liability. They needed to be fully committed before the ground shifted beneath them. Ethan watched the resort take shape through the winter and into the spring. The main lodge went up first, a structure of timber and stone with a wraparound porch facing the lake. Then the boat dock was constructed, a new one longer and more polished than the old wooden dock that had been torn out at the exact location where the original dock had stood for decades. Guest cabins were built along the southern shore. A spa facility was added at the north end. Landscape crews planted young trees to replace the pines that had been cleared, though the new trees were ornamental varieties that had nothing to do with the original character of the land. Victoria's name appeared regularly in local coverage now. She gave interviews. She attended ribbon cuttings for nearby businesses and positioned the resort as an anchor for a broader regional renaissance. Her photograph appeared on the front page of the county paper twice in 6 weeks. The mayor attended a preview dinner at the resort in late spring and was photographed shaking her hand in front of a Crystal Pines sunset. Ethan saw these photographs. He found them neither frightening nor infuriating. He found them, in a quiet way, useful. The grand opening was set for the second Saturday in June, and Victoria orchestrated it with the thoroughness of someone who understood that the opening was not merely an event but a statement. She sent invitations to every significant investor, every county official, every member of the regional business community who might be persuaded to associate their name with the project. She contracted a catering company from the city, hired a string quartet, arranged for professional photographers to document the evening, and personally approved the layout of the reception hall and the placement of the floral arrangements. The event was covered in advance by 2 regional outlets and a travel blog that described Crystal Pines Luxury Resort as one of the most anticipated hospitality openings of the season. 112 rooms were already booked for the first month of operation. 3 corporate retreat packages had been reserved. The resort's website, which had gone live in April, showed the lake at dawn with the tagline "Where nature meets luxury." Ethan arrived that evening in the clothes he wore to church, which was the same thing he wore to his wife's funeral, and to his father's funeral, and to every formal occasion of his adult life. He drove himself. He parked on the road outside the entrance, walked past the valets, and moved through the crowd without hurrying. The reception hall was full. The string quartet was playing something he did not recognize. The chandeliers, which were new and expensive, caught the light from the lake and scattered it across the ceiling. He recognized officials from the county planning board. He saw the mayor near the bar laughing at something. He saw investors in groups of 3 and 4 drinks in hand, looking pleased with themselves in the way that people look when they believe their money has made the right choice. He walked toward the main reception desk, and that was when Victoria saw him. She was 20 feet away mid-sentence with a couple he did not know, and her expression when she registered his face moved through several stages quickly. Recognition, confusion, irritation, and then the particular hard blankness of someone who has decided on a course of action. She excused herself from the couple. She raised her hand. The 2 security personnel who materialized from the edges of the room were fast, which told Ethan they had been briefed to watch for him. He did not hurry. He set the manila envelope down on the reception desk. He said to no one in particular that he believed someone in the room would want to see what was inside it. Then Rachel Morgan came through the side entrance with 2 colleagues and a court officer, and the evening changed. Rachel did not raise her voice. She did not need to. She presented the deed, she presented the original survey and the recovered boundary marker with its GPS documentation and Leonard Casey's signed affidavit. She presented the fraudulent easement document and the evidence of the notary's lapsed license. She presented the corporate records showing the relationship between the HOA and the surveying company that had redrawn the boundary. She presented it all with the efficiency of someone who has organized her materials carefully and has nothing to explain and nothing to justify. The court officer served Victoria Harrington with a certified copy of the emergency motion that Rachel had filed that morning. Across the room, Ethan could see investors pulling out phones. He could see a county official lean over and speak quickly into another official's ear. He could see a man he recognized as one of the lead investors set down his champagne glass and look at the woman beside him with an expression that was not festive at all. Victoria said at some point during this that this was harassment. She said it in a voice that was still composed but no longer entirely controlled. Rachel handed her a copy of the motion and suggested she contact her attorney. An hour later, the judge who had been on call for emergency filings that evening signed the temporary restraining order. Crystal Pines Luxury Resort was prohibited from conducting any further business operations pending a full hearing. The guests were asked to leave. The photographers were still there, and they photographed that part too. The formal hearing was scheduled for 3 weeks after the opening, and when it came, it lasted 2 days. Rachel presented the same evidence she had deployed at the opening, now expanded with expert testimony from Leonard Casey and a forensic document examiner who had analyzed the notarization stamp and given a written opinion on its invalidity. The HOA's legal team argued that the survey discrepancy was a technical error corrected through standard administrative process, that the easement was valid on its face, and that Ethan had failed to raise his objections within the applicable statutory window. The judge asked the HOA's attorney at one point to explain the corporate relationship between the HOA and the surveying company that had produced the revised boundary map. The attorney's answer took several minutes and satisfied no one in the courtroom, least of all the judge. On the morning of the second day, after the close of argument, the judge issued his ruling from the bench. The property in question had been and continued to be owned by Ethan Brooks. The easement as filed did not authorize commercial development and had been materially misrepresented in the HOA's planning applications. The boundary modification in the submitted survey was not supported by any lawful instrument and appeared to have been produced in coordination with parties who had a direct financial interest in the outcome. The restraining order was converted to a permanent injunction prohibiting any commercial use of the property. The matter was referred to the County District Attorney's Office and the State Real Estate Licensing Board for further investigation into potential fraud. Ethan sat in the back of that courtroom and listened to the judge read his ruling, and he felt something that was not triumph precisely, but was closer to the feeling of a weight he had been carrying for 2 years, being set down on the floor. The investors did not wait for the criminal investigation to begin. Before acting, 3 of the 4 primary investors had filed suit against the HOA and Victoria Harrington personally within the week, seeking recovery of their contributed capital plus damages. The HOA's board, most of whom appeared to have had limited knowledge of what Victoria had actually done in their name, moved quickly to remove her from her position. The county planning board opened an internal review of how the project had been approved with falsified documentation. The state licensing board launched a parallel investigation into the surveying company's principals. Victoria Harrington was gone from Green Valley within the month, not dramatically, not with any public statement, simply absent one day and not present the next, her name removed from the organization's website and her parking space in the HOA office lot vacant. The resort sat empty through the rest of that summer and into the fall. The polished lobby gathered dust. The guest cabins sat locked. The boat dock, newer and longer than the original, rocked quietly in water that now had no boats on it. Ethan was under no legal obligation to do anything with the property in the short term, and he did nothing quickly. He walked the land in the mornings the way he always had, and he noticed slowly that things were beginning to reassert themselves, not dramatically, not all at once, but in the small, persistent ways that land returns to itself when people stop interrupting it. Grass came up through the edges of the paved paths. Birds that had left during construction came back to the tree line. He did not tear down the resort buildings immediately. A legal process was underway, and the disposition of the structures was part of the ongoing litigation. But he did that first October after the hearing rebuild the dock. He used the same kind of rough-cut lumber his father had used, and he put it in exactly the right place, and he made it slightly wider so that 2 people could sit side by side on the end. He fished from it the following morning alone before the sun was fully up, and the lake was quiet, the way it had always been quiet. And the light came across the water in the way that light does when there is nothing to interrupt it, and it was enough. Children from the local area began coming back to the eastern bank that following spring. He had not advertised the access, he simply left the gate open. A few families with young children started appearing on weekend mornings with coolers and folding chairs and fishing rods, and Ethan would wave at them from his side of the property, and they would wave back, and nobody said very much, and the fishing was good. There is a particular kind of mistake that powerful people make when they look at someone who is quiet and patient and has lived long enough to stop being impressed by noise. They mistake the quiet for weakness. They mistake the patience for resignation. They look at a man standing alone at the edge of his own land, and they see someone who can be moved. What they miss, what Victoria Harrington missed, what the HOA's attorneys missed, what every person who told Ethan to let it go and take what he could get missed, is that some things do not move because they are rooted in something that money cannot replicate and noise cannot dissolve. A 48-year-old deed is not a sentiment. It is not an emotional claim or a matter of personal attachment or a story a man tells himself about the past. It is a legal fact recorded in the public record, signed and stamped and filed in a building 3 blocks from the courthouse, available to anyone who thought to look. The resort cost $12 million to build. The deed cost the filing fee that Thomas Brooks paid in 1978. In the end, the older document won. The lake at Crystal Pines is quiet again now. The mornings come the way they always have, with light moving across the water and the pines along the ridge catching the first hour of sun in a way that turns them briefly gold. Ethan is there most mornings, standing or sitting or sometimes fishing, not in any hurry, not proving anything to anyone. The people who told him to give up have mostly gone back to their lives and do not bring it up. The resort structures are still standing on a portion of the property, their fate still working its way through the courts, but they are quiet now and no longer anyone's success story. The dock is good. The fishing is good. The land is still exactly what it was, minus the noise. The loudest people in the room are not always the ones who own it. Sometimes the proof is in the paper, and the paper is older than the money. And if you are patient enough to wait for the right moment to put it on the table itself has a way of shifting. Victoria Harrington understood a great deal about leverage and timing and the management of public perception. What she did not understand, what she perhaps could not understand, was that some things are not negotiations. Some things are simply facts, and a fact given enough time and the right moment will surface on its own, the way iron markers surface under the right instrument, right where they were placed 50 years ago, waiting.